The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good morning. The next case is in re Q.P.W, and we will hear from the appellant.
Chief Justice Newby, Honorable Justices. May it please the court, my name is Anique Lenoir Peak, and I am the Deputy Parent Defender for the state of North Carolina. I represent the mother in today's case. At this time, I'd like to reserve 10 minutes for rebuttal, if I may. I will be using a pseudonym for the mother, as she was a child victim during the majority of the pendency of this case. The issue today is whether the trial court can conclude the termination of parental rights grounds should apply to a 19-year-old parent who voluntarily participates in the 18 to 21 foster care program in the same manner as it applies to others. We ask this court to find that similarly to underage parents, that the totality of the circumstances must be considered when determining willfulness and grounds. The 18 to 21 foster program should be a safe harbor for young parents and a tool for family preservation. At the age of 13, Alexis was raped by a 20-year-old, which resulted in her pregnancy with the child in this issue, Quentin. Her mother was convicted in her rape. Alexis and her twin sister were placed in the care of their maternal grandmother. About 3 days before Alexis gave birth to Quentin, the grandmother placed 14-year-old Alexis in the care of DSS. She said that she lacked the funds to support both of her daughters to deal with the pregnancy, and also Alexis had become difficult to handle. Quentin was adjudicated dependent because his 14-year-old mother was herself in DSS custody, and she was unable to provide the required follow-up medical care that he needed. Early on, the trial court instructed DSS to make every effort to keep Alexis and Quentin in the same placement. Alexis's plan required her to address mental health needs, learn how to parent, complete her education. She was to attend all of Quentin's medical appointments. She needed to follow the rules of her placement provider. She had great success and learned a lot when she went to the Florence Crittenden Home for Young Mothers. In the ensuing years, Alexis learned not only how to take care for herself, but also for her son. Then Alexis rebelled. She disrupted over 10 placements. At times, she would tell her social worker that she wished for herself and Quentin to be moved, and the social worker would not honor her requests. Each time she ran away, she took Quentin with her. At no time was Quentin harmed, and he was a happy little boy who was well bonded to his mother. At most of the placements, Quentin had his own toddler bed in his mother's room, and she was primarily responsible for all of his care, including medical appointments. On November 30th of 2017, Alexis turned 18. Like so many young people, she decided she would try to adult. She set out to establish a home and so that she could regain custody of Quentin. But her 4 years in foster care did not prepare her for what the real world would be like. She struggled finding employment. Whenever she tried to reside with a relative, like her grandmother, her sister, or her father, DSS told her that the home would not be approved for Quentin because of their involvement in DSS's case regarding Alexis. 9 months later, on August 9th of 2018, Alexis signed a voluntary placement agreement, returning to DSS's foster care program for 18 to 21-year-olds. As part of the program, she had to work 80 hours a week, 80 hours per month. She had to meet monthly with her social worker. She had to follow the rules of the program.
Is that the LINKS program?
I'm sorry?
Is that the LINKS program?
That is the LINKS program. The LINKS program, though, is any program for children that are getting ready to age out. So I wanted to specifically mention that this is a new program that was initiated October 1st of 2015. that includes specifically for 18 to 21-year-olds that age out of foster care. But yes, I'll alternately call it the LINKS program and the 18 to 21-year-old program. So she had requirements to participate in the program. In exchange, DSS agreed to assist her with housing and getting on her feet. The court was tasked with reviewing the placement every 3 months to ensure that services were being provided and that she could continue to participate. The record is silent as to whether this occurred or not. Visits between Alexis and her child stopped in January of 2019 because she had missed too many opportunities to visit with him. She had also a child support order that was put in place as of July of 2018, setting the minimum amount of $50 per month effective September 1st. That was to take place through wage withholding. She didn't always have a job. And when she did work, she worked at places like Wendy's and McDonald's, earning $9 an hour, sometimes a little more than that. On April 2nd of 2019, the same DSS that raised Alexis filed a petition to terminate her parental rights. The court did make findings that at the time, Alexis had entered into a voluntary placement agreement with DSS in this LINKS 18 to 21-year-old program, and that she was receiving services and financial assistance to assist her in developing and achieving goals for independent living and utilizing services and support. Alexis' childhood was taken away from her, and now we've also taken her child away from her. We're asking this court to issue a rule that's very narrow, which is that this is not the kind of parent that the TPR statute was written for. In other words, young.
So you may be getting ready to answer my question, but I mean, what does that mean as a practical matter? Are you suggesting that in the event that a parent is in the LINKS program, that they are then immune from being the subject of a parental right of termination? Or do you mean, are you suggesting that we ought to impose a findings requirement like the one that is applicable to juvenile parents?
Thank you, Justice Urban. I'm actually asking for the second one, which is that we need to consider willfulness in light of the young parents' participation in the LINKS program.
What would be the would there be a similar requirement for parents in the 18 to 21 age group who are not in the LINKS program or a program like that?
I have not argued that because in the last 5 years, this is the only case that I can recall coming through our office in which we have had a parent who has been terminated who was a participant in this 18 to 21-year-old program. I will honestly say that I have no feeling for how many participants are in this program, how many of them are parents themselves. The argument I'm making is that we just need to extend the consideration and weighing of the willfulness as we do for juvenile parents to this group, this subset of group of parents.
Right, thank you.
You're welcome.
How would we measure that? Would that be substantial compliance if everything hasn't been formally met? Would it be good faith compliance? Where would we draw the line on something like that if we would adopt your desire?
Justice Morgan, that's a very good question. Here, my concern here is that we didn't even look at whether or not she was compliant with that program. I haven't really set out an argument in my brief as to whether it should be substantial compliance or not. What really happened in this case is that, and what concerns me really about this program is that this program is meant to be a safe harbor, right? It's supposed to help young parents get on their feet the way that our own children who are 18 to 21 need a little bit of a nudge. And so here, it doesn't sound like the social worker who was working with Alexis in the 18 to 21 program was either communicating, or do they even have an obligation to communicate with each other as opposed to, talking with Quentin's social worker. So the program for both of them and getting them independent should be working hand in hand. It's the same agency. I would assume they're in the same building, but I don't know that to be the case. I just think that if we are helping young parents to get on their feet, then we need to consider whether or not the case plan in the 18 to 21-year-old, and if she's compliant, whether that or not undoes the willfulness that would otherwise be found. I don't know that that's a great answer to your question, Justice Morgan.
Well, it satisfies me from the standpoint of the curiosity here. It seems as though the mother was better in her links plan that was designed for her, as opposed to the case plan that DSS had for her reunification with Quentin. How would the two of them be juxtaposed with one another in your vision if she's not doing what she's supposed to do, or a mother's not doing what she is, or a father even is not doing what that parent is supposed to do with the child's case plan, but is doing better in the links program?
I get that. And it seems that the case plan here was meant to address her housing and her employment, two of the things that are also relevant to Quentin's case plan. I'm going to call it that way. Quentin's case plan to refer to the child's case plan as opposed to her case plan in the links program. And the links program also, I imagine, because I am not super familiar with the program, is meant to help her with any other needs that she has, like mental health. I mean, she was a child victim here, and it seems like this issue gets lost a little bit here. And I think the things that she was missing from her case plan, aside from employment and housing, were mental health and parenting. But the issues with her parenting was she had completed a parenting program. All of the reviews of her visitations with Quentin are excellent. She's getting down on his level. She's playing with him. Then something happened. Like, all her missed visits happened during this 9-month time period when she was trying to learn how to get on her own feet. And
I mean, is it unfair to read the record to say that she was actually doing, except for the fact that she was repeatedly leaving placements, that otherwise she was doing okay up until she began to, as you put it, adult, when she turned when she reached the age of majority, and that her level of compliance with her case plan plummeted at that point? Is that fair?
I think that's a fair statement, Justice Urban.
If I go ahead, I'm sorry.
No, I was going to say adulting has become my new favorite phrase. And, I think that happens with a lot of young people. They think it's super easy, right? You turn 18, you just go get money out of the ATM and you live your life. And that's just not what happens.
Well, to go back to your proposal that we include some type of findings or requirement for people in the links program, you made reference to a willfulness requirement. If my memory is not failing me, two of the grounds for termination that are at issue in this case, abandonment, failure to make reasonable progress, already contain a willfulness requirement.
They do contain.
What does your proposal require in addition to the willfulness associated with the failure to make progress and abandonment?
It contains the same things that it does with like a teenage parent that is underage, right? So, like, we have to look at the willfulness in light of her situation in the links to 18 to 21 program.
What does that mean? Now, we've got some history with the requirement that there be findings that the juvenile parent's non-compliance with the case plan isn't due to the juvenile's age and immaturity. I can kind of come to grips with that. What is the additional set of findings that you think ought to be required in a case like this, where we've got a parent who is a legal adult but is still participating in the links program?
So, especially on the ground of abandonment, I think that the fact that she returned the same agency that filed and terminated her, and sought to terminate her parental rights shows that she is still willing to engage with the agency, and also that she paid child support during this time period. I understand that there's disagreement as to the amount of child support that she paid, but there's no finding, or there's not, I challenge the finding of fact that she had not paid child support during that 6-month time period. I would hate a rule that says that you abandon your child if you fail to pay child support during that 6-month time period. And the reason is that we already have that as a separate ground, right? That's 7B1111A3. And we don't want to discourage parents from paying child support, even if they're not seeing their child. So she's not foregone.
With respect to that particular point, why would there be a difference between a child with a parent in a links program and any other parent? Couldn't you make the same argument with respect to any parent, regardless of age, that you shouldn't consider failure to pay support in determining abandonment?
Yes, Justice Irvin, and you can't, right? It's part of failure to pay child support, is part of abandonment, and it's part of neglect even. What I'm saying is that you can't use that as the sole measure. And if a parent is paying, then I don't think they've foregone all of their obligations and duties, which is what abandonment requires. Abandonment requires a willful failure to act in all respects as a parent. And here, she, at the very least, was paying child support during that time period. And I don't think we've interpreted it that way in other cases for other parents as well.
How would your proposed requirement apply in the failure to make progress area?
So in the failure to make progress, that she came back into the 18 to 21 program, I would think that the court would want to look at whether her case plan on the 18 to 21 is also working with the case plan for Quentin. In other words, are we helping her or are we not helping her? I mean, part of this is our obligation in also getting her on her feet. And if she said, no, forget it, I'm not going to do that, then we need to look at, is this part of the reason for Quentin's removal? And I know that we have disagreement with the other side on what is Quentin's reason for removal. Originally, it's because his mother was 14 and she needed to learn how to take care of herself and get on her own 2 feet. She's trying to get on her own 2 feet. That's what the Links 18 to 21-year-old program does. It helps these young parents who have been raised by DSS for 4 years get on their feet. And that's what I'm asking for here, is that then we would look at the willfulness in light of, is she participating with the Links program? Is she being willfully disrespectful of that program? Is she not cooperating with the social worker? I guess I'm just confused as to why one social worker is not communicating with the other social worker. And is that the responsibility of a parent with whom we've said, in exchange for your entering into this 18 to 21-year-old program, we're going to help you. We're going to help you to provide services for you to become an independent adult. And I get it. I mean, I get that she's 18. She's 19 at the time of the termination. I get that we have other parents whose rights we terminate who are in this 18 to 21-year-old group. I am not asking for anything different for those parents. I am simply stating that when you are a foster child who has aged out and have chosen to, that your experiment with adulting didn't work out quite so well, that you're coming back into the fold, then that should be a consideration as to whether or not she has willfully abandoned her child and whether or not she has willfully failed to comply or to remedy the failure to reasonably remedy the situation that led to her child's removal, which in this case was her immaturity and her young age. She was in 8th grade when she had her child. I just can't imagine that I would have been 8th grader with a child of my own. And so these are the things that I'm asking this court to consider. I understand that I'm asking for an extension of the willfulness analysis. The totality of the circumstances have to be looked at when you are an 18, 21-year-old in this special program. And one of the interesting things about this program is that you can re-enter it at any time until your 21st birthday. So here we have her trying for 9 months, and then she entered the program, and she was actually eligible for the program until November 30th of 2019. I can't do math, I'm so sorry. Until 2020. So she's been available and have this program, and I think that's what we need to do. We need to give these young parents all the tools we can so that they can parent their own child, because clearly that's why they age out of foster care, is that they don't have that resource at home. They don't have someone showing them how to parent.
With this extra layer that you are suggesting with a presence in the links program, are you asking for a bright line rule here that would give a juvenile mother or father an opportunity to have some insulation by virtue of just being in the links program? Or are you saying that this court, in recognizing the links program, would need to look inside the links program, figuratively speaking, to see how that individual has been performing in the links program as a part of the evaluation as to whether or not it's in the best interest for parental rights to be terminated?
Justice Morgan, that's the second option is what I'm asking for. I am not asking for a bright line rule, just as we don't have a bright line rule for juvenile parents not being able to be terminated. So if she was participating in the program and not caring about the rules or not following them, and that would be something that the court would consider in evaluating her willfulness for the grounds as to Quentin. That's what I'm asking for, that it simply be considered as part of the analysis, the totality of the circumstances leading to the analysis. I see I'm into my rebuttal time. If I may, I'd like to reserve the rest of the time unless there's any pressing questions I can address.
We'll now hear from the appellate.
Good morning. My name is Mercedes Chutt, and I am representing the Guilford County Department of Health and Human Services. I plan on using 15 minutes of our time, which I'm sharing with the attorney for the guardian ad litem, Mr. Chris Wood. Just going right to the heart of the matter, because our time is limited. The argument that the appellant mother is making was not raised at all in the trial court. The record in the trial court is almost void when it comes to the links program. And that is because the argument about the links program was not raised in the trial court. The best I can tell from the trial court, and I have reviewed the entire transcript and the record in preparing for this argument, is that the mother did join the 18 to 21 program. I believe it was in August of 2018. And the 18 to 21 program or the links program, this is not clear because the record isn't clear. There's no evidence in the record about this, but through this program or the links program, the mother had to work 40 hours per week. That is the only known requirement that one can ascertain from the record. There are 2 references in the record, I believe, in the transcript, to a links coordinator named Ms. Shalitha Stewart, providing the mother with housing leads. There is no indication in the record that the mother actually followed up with the housing leads. So while Ms. Lenore Peak's argument that young adults who are participants in the 18 to 21 program, her argument that should be considered in connection with the termination of parental rights action, that may be an interesting argument or a valid argument, if the record supported it, if the trial court had considered it, if there was any information in the record that allowed one to determine if the mother was even compliant with the 18 to 21 program. So the record doesn't contain information as to what the 18 to 21 program is, what it required, or whether the mother was compliant. Now, in terms of the grounds to terminate parental rights, one thing I think that's very important to note is that none of the findings of fact, from what I can tell, have been challenged. And so I think our case law is clear that findings of fact, which are not challenged, are deemed conclusive on appeal. They are the law of the case.
Can I ask you one? I'm sorry. Can I ask you one question about the findings and whether or not they're challenged? I thought the finding about the payment of child support was challenged, that the correctness of that finding was challenged because the argument is that the testimony didn't make clear the period of time that the arrears had accrued. And so the trial court finding was not correct as to the 6 months immediately preceding the filing of the action. It could have been those arrears accrued after the filing.
My understanding from reading the brief is that the finding was not specifically challenged as challenging a finding of fact. So there is a finding that states that the mother entered into a child support order on, well, it was effective September the 1st, 2018, which required her to pay $50 per month. And then there's a finding that the mother only paid $123 and change during the 6 months preceding the filing of the termination petition. And so I think that the challenge was the conclusion of law, that those findings supported the conclusion that the mother had failed to pay a reasonable portion of the cost of care. So it's in my understanding the evidentiary findings were not challenged. The conclusion, or perhaps the material finding, that the mother had willfully failed to pay a reasonable portion of the cost of care may have been challenged, but I think the facts are not challenged, that she paid $123 and change during the 6 months period.
So the argument, so your contention is the argument that the evidence didn't give the trial court the ability to conclude what the arrears were during the relevant time period, that argument doesn't sufficiently challenge the finding of fact because it doesn't say it's challenging the finding of fact? Right.
So I look at the findings in terms of evidentiary findings and ultimate findings. The evidentiary finding, and this is in Re O.W., there's a lot of cases that cite this idea, but the evidentiary findings would be that the mother was under an order to pay child support in the amount of $50 per month starting September the 1st, 2018, and that she only paid, it was $123 and something like 54 cents or 26 cents, but that's all she paid in the 6 month period. Those are evidentiary findings. I don't believe those are challenged. I think the challenge would be that those findings support a conclusion of law or an ultimate finding that she did not pay sufficient child support or sufficient cost of care during the 6 month period. That's my understanding. I don't know. I don't know that it's completely clear, but if one looks at the evidentiary findings, particularly starting with finding 14 of the termination of parental rights petition, the 14A through, it keeps on going, several subparagraphs. I don't know that those are challenged. It's not clear to me that they're challenged in the brief. And I would argue that they support conclusions of law, certainly 1111A1, 2, and 7.
And so what is your position regarding what finding is necessary to sustain that ultimate conclusion? How much is not or how much is too little, and how much would the mother have had to pay to avoid losing her parental rights on this ground of failure to pay support?
So my argument is the findings of fact could have been improved, the material findings. There's no question about that. But what we have, this is a question really sort of math. What we have is the mother was under an order to pay child support in the amount of $50 per month starting September the 1st. The relevant time period was for this ground 1111A3 was from October the 2nd to April the 2nd. So we know that during that time, the mother was supposed to pay $300 under her child support order. Now, a child support order is a presumption of the reasonable portion of the cost of care. It can be rebutted. It was not rebutted in this case. So, you know, doing simple math, the mother was supposed to pay $300 during the relevant time period. She paid $126 and change. And, you know, my argument is that from doing that math, the court could properly conclude that the mother did not pay a reasonable portion of the cost of care.
So your argument is that the law is that if she pays anything less than the 300, that's sufficient to establish that ground. If she paid $295 during that period, she still would have failed to pay the reasonable cost of care and be vulnerable to termination on that ground.
It's not entirely a mathematical equation, because you have to find that the mother willfully failed to pay a reasonable portion of the cost of care. So if she did, I mean, if she had paid $295 and there was some sort of extenuating circumstance, that would be a different case and another argument. You know, I think, you know, Ms. Lenore Peak is asking the court to look at the totality of the circumstances. I think that our case law holds very clearly that we look at the totality of the circumstances with respect to every ground. And so certainly with, you know, willful failure to pay a reasonable portion of the cost of care, you know, you look at all the circumstances. The circumstances here are the mother, basically, she reported income during the relevant time period. I don't think she provided documentation to the department, but she, on her child support worksheet, she disclosed zero income. As a result of that, child support enforcement set child support at the minimum amount of $50 per month. And then the mother did not pay that minimum amount. And there's nothing in the record that indicates the mother was under any type of disability or could not pay the minimum amount. And my argument would be that under those facts, looking at the totality of those facts, it does support the ground of 1111A3. And also, you know, the other grounds I think are very strong given the contested findings, which are neglect, 1111A2, and abandonment, 1111A7. And just turning to the ground of abandonment under 1111A7, the uncontested findings of fact show that after the mother turned 18 in November the 30th, 2017, she abandoned her case plan. She abruptly left her placement, her joint placement with the child. And she, at that point, really did not cooperate with the department at all. Her communication was minimal. And in August of 2018, she stopped visiting the child altogether. The termination petition was not filed until April of 2019. And the mother argues in her brief that she didn't have the ability to visit because the court suspended visits. Actually, the court did not suspend visits until January of 2019. And by that time, the mother had missed multiple visits. And she didn't give an excuse for missing the visits. She didn't move the court to reinstate the visits. She just didn't visit. The mother had minimal contact. She didn't send the child cards, gifts, tokens of affection. She sent one birthday card. That was at the instigation of the social worker. And so the fact that the mother has withdrawn love and affection from the child, I think under the uncontested findings, certainly supports 1111A1 and 1111A7.
What's your reaction to the mother's position that there was a payment of some child support? And so hearkening back to my learned colleague, Justice Earls, if it's not absolutely clear as to when child support payments were made versus when they weren't made, especially in light of some participation in the LINKS program, which did have the mother working at some times and therefore paying child support, that the child support obligation is somewhat blunted somewhat blunts the abandonment force of strength here in terms of there being some child support paid, therefore abandonment is questionable.
Okay, I'm going to try to answer all of your questions. So
yeah, it wasn't very artfully said. I'm sorry.
I don't mean to say that at all, Your Honor. So when you're looking at abandonment, again, you're looking at totality of the circumstances. And the 1111A3 ground is, of course, a separate ground, and the grounds don't overlap. So one can pay some child support and still have abandoned the child. My argument with, and then going to the LINKS program, I think the LINKS program is almost an argument for abandonment, because if the mother could participate in the LINKS program, and again, it's not clear from the record what the LINKS program involved or whether she really did participate in it and follow whatever rules it required. But if she was able to do that, then certainly she could work on her case plan. Certainly she could visit her child. At that point, the case plan, I think, required pretty minimal things. The mother was to go to parenting classes. She was to cooperate with random drug screens. She was to take a substance abuse assessment, and she was to have a comprehensive clinical assessment for mental health, go to counseling, and maintain housing and employment. And she didn't do any of that. She didn't do any of that from her 18th birthday. And so I think there's a more recent case that was not cited in the brief, and I'm trying to find it right now. CBC, this court decided it's 373 NC 16, and it's in my additional authorities. In that case, the court basically focused on whether the parent was withholding love, affection, the opportunity to display filial affection. And the court is distinguishing between acts that the parent did that actually further the parental relationship and acts or conduct of the parent that do not further the parental relationship. And in that case, the respondent father argued that he had challenged the TPR petition and he had sent a card to his daughter. And this court found that, those weren't actions that further the parental relationship, because the overarching thing to try to look at with abandonment is, does the parent want to be the parent? And yes, there were 7 child support payments made. The evidence actually shows 2 in the amount of $11 and some cents in October, one on October the 5th, one on October the 15th, and then there was a $100 payment in January. But you have to look at the totality of the circumstances. And when you couple that with, not visiting when you can visit, missing 21 scheduled visits, not communicating with the social worker, not sending the child cards, gifts, tokens of affection, except at the behest of the social worker. That's why I think that the act of paying child support during the 6-month period does not preclude abandonment. If I've answered your question in kind of a long-winded way. And so I'm out of my time, so I'm going to segue to my co-counsel.
Thank you, Ms. Shelton. May it please the court. Thank you, Mr. Chief Justice. I want to follow up beginning with Justice Morgan's question, and then I'm going to try and jump to Justice Earle's question about 1111A3. And then, time permitting, I'm hoping to wrap up on this LINKS argument. We'll see how that goes. Justice Morgan, I want to make clear, I think there's some question about the trial court's findings of fact, specifically finding 19 and 26 regarding what amount was paid and when that amount was paid. The trial court hears evidence, and that's coming from transcript pages 100 through 105 on redirect examination, saying that, look, there were 2 payments in October of 2018 of $11.54, and there was 1 payment in January of 2019. That's coming off of a May 2019 report, which is is showing that there's no child support paid in November, December, February, March, April. So the record is, I agree with Ms. Chutt, the trial court's findings of fact could have been more artfully drawn. But the point is that the trial court correctly determined that there had only been $123.08 paid as of the date of the termination hearing. The trial court, I understand, also calculated arrears as of the date of the order. There were $123.08 paid as of the date that the petition was filed. The trial court also calculated arrears as of the day that the order was entered or as of the date of the hearing. I don't know that that matters much, except to bolster the conclusion that child support is not being paid with regularity. Now, to your point, Justice Morgan, Mother has only raised two challenges to the subsection A7 determination. First is the child support issue, and second is participation in links. The child support issue, I would submit, whether or not that cuts in favor of the department or in favor of the mother, is a question of fact. It's one that the trial court received evidence on. It's one the trial court weighed. And as Mother articulates in her brief, the child support issue can't be determinative under subsection A7. It's just a factor. And here the trial court determined that it was a factor that cut against the mother and in favor of the department. I think that segues into, and this is a roundabout way to get there, but I think that segues into Justice Earle's point about willful failure to pay the reasonable cost of care of the child. Again, Justice Earles, I hope that explanation of the record clarifies what has and hasn't been, when child support payments were made. The thing I would highlight is that we know that Mother was under a child support order. We know that during the 6 months preceding the filing of the termination petition, Mother was obligated to pay $300 for Quentin's support. That is the reasonable cost of support. And as Ms. Chutt says, that can be rebutted, but I understand Mother's brief to concede that the September 2018 child support order did establish the reasonable cost of Quentin's care.
Mr. Edwards, just to make sure I'm not losing track of things here, it is true, though, that the trial court's findings don't contain dates for the specific payments, correct?
Yes, Justice Ervin, I would concede that. The trial court did not make specific findings as of the date, though the evidence supports the trial court's determination that as of the date the petition to terminate parental rights was filed.
Does it matter that if you've got record support for a particular finding, that finding isn't made?
I think no, Justice Ervin. I think that if the finding it's inherent from the trial court's finding 19 based on the evidence that was submitted. So in finding 19, the trial court does find that Mother has only paid $123.08, and that is supported by the record. So I think that finding standing alone should be enough to affirm on the A3 ground.
Thank you.
Justice Earls, I noted that you and Ms. Chutt discussed a little bit whether a finding had been challenged. I think I read the record a little bit differently in that Mother does specifically challenge finding 26. I don't know that matters, though, because the critical finding is finding 19, and I don't believe that Mother does challenge that. She mentions challenging finding 19, but I think that has been waived because there's no specific argument, there's no evidence cited as to how that finding is incorrect. So finding 19, I think under Appellate Rule 28B6 and under this court's precedent, I think that challenge has been waived or has been abandoned on appeal. Even if
Oh, I'm sorry. I wanted to ask you about a different ground that, and make sure I'm clear on your argument. You do argue that the trial court erred in terminating the parental rights under 1111A6, and there, do I understand that your argument is that the findings are not sufficient to support that legal conclusion?
That's correct, Justice Earls. The 1111A6 ground, as I understand the case law, and I believe in conversations with Ms. Chudd, I can represent to the court that she also has conceded the ground by not arguing it. The 1111A6 ground requires more than occasional drug use under cases from this court and from the Court of Appeals. As those findings are written, they are nothing, they establish nothing more than occasional drug use. So I believe it is inappropriate that the trial court terminated parental rights under 1111A6. That's not to say that mother's drug use could not form some other basis if that had been, for example, a critical part of her case plan. I don't think I'm willing to concede that sporadic drug use, if it's part of a case plan and a larger totality determination under subsection A2, that might be relevant. But here, just for that independent finding, that very narrow finding, and conclusion, we do concede that there's no support for that in the record.
Thank you.
I'd like to pivot to 1111A2 in this discussion of the LINKS program, which I think undergirds so much of Mother's argument. I'm a little troubled to hear that Mother thinks that the LINKS program creates some sort of special rights in her and in other juveniles participating in the 18 to 21, the LINKS program, what have you.
Mr. Edwards, I'm not sure if I understood Ms. Minois-Peak's argument, and she can correct me on rebuttal if I didn't, but I think she's saying ultimately that the fact that a person is in the LINKS program should result, there should be a requirement that there be additional findings concerning the extent of that person's compliance with the requirements of the program. That may not be what she's saying, but I asked her several questions to try to figure out exactly what she was saying, and that's essentially what I got out of her answers. If that's what she's saying, what is your reaction?
Justice Ervin, I think that muddles the statutory scheme, the separate statutory schemes for LINKS and for termination of parental rights under Chapter 7B. I think the legislature was clear that the trial court needs to make findings as to whether the parent's compliance with the case plan or non-compliance with the case plan was willful. And I think that is necessarily subsumed in the willfulness analysis. I don't think.
Let's say we had a lot more evidence than we do about the extent of the mother's compliance with the LINKS plan. Do you think that such evidence would be relevant to the determination of whether grounds for termination exist in this case?
Not necessarily, Your Honor. I think the LINKS program, I think evidence of participation in the LINKS program can be relevant if it relates to one of, for example, housing under the LINKS program and housing under the case plan certainly go hand in hand. But if the LINKS program and the case plan are different from each other, if they contain different requirements, where there's no overlap, I don't know that necessarily is relevant to the ultimate determination.
Would it be fair to say that the LINKS program is focused on helping the participant improve in life skills, and on the other hand, termination of parental rights focuses on the parenting of the child and the fact that a child needs a parent every day of the child's life, and the General Assembly, having balanced the constitutional rights of parents versus the needs of a child, have come up with a statutory scheme that they believe focuses on the child as opposed to the parent.
That's correct, Justice Newby. That is, I think, the best way to summarize my argument on this point. These programs are directed at different things, and the the foster program, the termination of parental rights, everything contained in Chapter 7B is really focused on making sure that the child has a parent. And the LINKS program, as Justice Newby just said, is focused more on making sure the parent has life skills. To Justice Irvin's question, that's not irrelevant. I mean, those two things can go hand in hand sometimes, but I don't know that there is some sort of necessary additional finding based on the discrete aspects of those two programs.
But if you've got a situation where in the LINKS program, it is, to coin a phrase, parent-centric, and the DSS case plan is juvenile-centric, then if you've got, as I've read in one of the briefs, I think it's the mother's brief, the fact that you've got one of the DSS workers in one of those programs talking to the other DSS worker, but the same information is not coming back from the other program, then isn't one of those proverbial aspects where the left hand potentially doesn't know what the right hand is doing, and the mother, meanwhile, is not getting the benefit of having those DSS workers communicating with one another on two DSS administered programs.
I understand what you're saying, Justice Morgan, but I don't know that mother is necessarily entitled to have those two DSS workers communicate with each other in the context of a termination of parental rights hearing. I mean, if we're focusing on, as Chapter 7B does, what is in the best interest of the child, and this court said repeatedly that's the polar star, what's in the best interest of the child is not really having mother communicate second or third hand from a social worker, but is having the mother directly engage with the program. I think that's also apparent in the different statutory schemes establishing LINKS and establishing the foster care system for juveniles. It's that mother is responsible ultimately for the case plan. And while LINKS may help her work her case plan, it is not necessarily dispositive. Very quickly, before my time runs out, I do want to focus a little bit on mother's argument that parenting shouldn't be involved in her case plan and address this court's decision in BOA. As Justice Irvin wrote in BOA, the case plan can focus on conditions that led directly or indirectly to the removal of the minor. Here at 14, I don't know that there is any question that a 14-year-old, I think as Ms. Lenore-Peak has, I would say, conceded, a 14-year-old doesn't know how to be a parent. And so that was part of her case plan. She was required to work that case plan. The case plan was allowed to adapt, and it did adapt. And unchallenged finding of fact 14B supports the trial court's determination that it should terminate parental rights under subsection 8.2. With that, we ask that this court affirm.
Thank you, counsel. Rebuttal?
Yes, thank you, Your Honors. I did want to address the child support issue since that came up during opposing counsel's argument. I did challenge findings of fact 19 and 26. Those are found at my brief at page 15. And I also argued that
and again, just to make sure I'm following you, I didn't understand your argument to be that anything that was stated as a matter of fact in the sense of something that happened in history, in time and place, were wrong. I understood your argument in essence to be that the findings that were made did not support a conclusion that your client's grounds were subject to termination on the basis of A3. Did I misunderstand your argument?
No, you did not, Your Honor.
Okay.
One of the things that I argued was that there was not a specific finding as to the time period, even if I conceded that the findings of fact themselves individually supported any amounts that were paid.
So to put it in kind of standard of review terms, you did not challenge the findings that were made. You argued that the findings that were made did not suffice to support a conclusion that your client's parental rights were subject to termination on A3 grounds?
Yes, Your Honor. And actually, if you look at in Re KH, which this court decided 2 months ago, not quite 2 months ago, that was one of the things. I mean, so many of these cases come out at a time, I have to try to keep track of them. But in KH, this court specifically said that because the 6-month time period wasn't addressed, we didn't know what the arrearage was at the time of the filing of the petition, so the look back period. And so we have the same thing here. Even with these findings of fact, we don't know what the amount was in arrearage during that time period. And again, math just doesn't add up. But I did want to talk then about the case that was mentioned by Ms. Chutt in Ray CBC. In that case, the father for abandonment had also not made any child support payments. That's not what we have here. We have someone who has made some child support payments. And then, you know, not every parent who is 18 to 21 qualifies for the LINKS program. This is a very narrow set of parents. These are children, well, now young adults, who have aged out of the foster care system. That's who I'm asking that this totality of the circumstances include a look at the parent's circumstances and participation in the LINKS program.
Ms. Chutt suggested that this is an appropriate case to decide that issue because the record is rather slim in terms of what was the extent of your client's compliance or non-compliance with the LINKS program. What's your response to that?
Yes, so there was actually a finding of fact about the LINKS program. It is pretty scant. It's simply, it's at record page 333, finding of fact 14A, which discusses Alexis's entry into this voluntary placement program in that she agreed to have an employment of at least 80 hours per month and that she would receive services and financial assistance to help her develop and achieve goals for independent living and utilizing services and support. So we have
you know, so we've got that information about it. Those two parts of the LINKS plan apparently overlap with the parts of the case plan associated with the juvenile. In the event that there are, you know, are you contending somehow that the trial court's findings with respect to the areas of overlap are deficient?
I don't know that we know enough. I did not challenge any of the specific.
Okay, if it's a situation where we don't have the evidence, are you suggesting that there be some affirmative burden placed upon the Social Services Department to elicit evidence?
Well, it is their burden, after all, to prove the grounds by clear, cogent, and convincing evidence. So,
well, based on what we know now, what basis would DSS have had at the time this case was tried to understand that they might have an affirmative duty to show the extent or lack of consent of your client, or the extent of your client's compliance with the LINKS program?
First off, they're both social workers for the same agency. So I think that's the first consideration that needs to be kept in mind. And secondly, they already do this in juvenile cases. I mean, so I don't know that this would have been, I mean, what's the purpose of the 18 to 21-year-old program otherwise for young parents? I just don't know how much it helps them if we're helping them get on their feet, but we're taking their children away from them, or at least not giving them an opportunity. There was likewise no testimony, as Ms. Chutt conceded, that mother was not properly participating in completing this LINKS program. So I think it cuts both ways. Do we have a lot of facts here? Maybe we need for it to be remanded. We actually asked that it be reversed and vacated, but perhaps that's what the court needs to hear, is actually more testimony on whether or not she can parent and whether she was in compliance with her LINKS program. I don't know if that answers your question, Justice Ervin. Okay, thank you. So, you know, this case is unusual, and I will concede that this is the first time that I've seen this kind of a fact pattern. We're not asking for a huge expansion of protections, automatic protections For 18 to 21-year-old parents who are in the system, we are asking simply that a teenage parent who participates in this 18 to 21 links program, that we're helping them to become independent. And so we need to recognize that we need to help these parents, or at least consider whether or not they are participating in a full program in order to find willfulness, and we need to look at it through that lens. So we're asking for a very narrow rule, which is to expand the determination that has come out of the juvenile cases with underage parents, that yes, it is possible for parental rights to be terminated on willful grounds, but that in determining whether they're willful or not, that this court must consider whether or not the parent is appropriately participating in the Links 18 to 21 foster care program. I see that's basically my time, and we ask that you reverse and vacate the termination order, and I thank you for your time.
Thank you, counsel. Thank you to all counsel. Madam Clerk.
Oh yes, oh yes, oh yes. The Supreme Court of North Carolina will be in recess until 2:15 this afternoon. God save the state and this honorable court.